Okay. So, hello everyone. This is Himanshu, founder of GoTrust. Together with me, we have Arya. She is a partner at see camps. That's even best way. Sorry guys, this is bothering me. Let me put my laptop on silent. Last minute things. But yeah, they always bring this trouble. So, hello everyone. This is Himanshu once again, founder of GoTrust. Together with me is Arya, who is partner at Camps. What we're going to discuss today is something very important. DPDP is out now, and now we have a challenge of identifying the automations within the end-to-end process. Today, we're going to focus on the consent piece because that is something which has been discussed a lot, and we need to identify what are the big puzzle, and we have to break it down into multiple pieces, how we can automate each piece so that we can be compliant, and not only compliant, be compliant with an ease, because that's the bigger challenge which I see a lot of teams, a lot of uh, CISOs, a lot of DPOs are having struggle with that, how the consent is going to be automated, how it's going to be implemented deep into the existing ecosystems. So that's something we're going to discuss today. And for that, we have Arya. So I will ask Arya to introduce herself a bit. I've already did it already, but again, a bit on the DPDP side, how she's looking at it, and what's her approach here on this part. Hey, Arya.
Himanshu, unfortunately, I don't think I'm able to hear anything. I'm not sure if it is a problem at my end, but
Okay, no worries. Let me check. Uh, Maybe it's better if you can kill the camera. Maybe that's easy for you. Arya, can you kill the camera? Guys, Arya is having a bit of trouble with the internet, so she's going to rejoin. So hang on with us, and then we're going to do a deep dive. Sorry, I was on mute. Can you hear us now, Arya? I think.
yes, I can. I can now,
Okay.
loud and clear. Thank you, Himanshu.
No worries, no worries. So I just gave a small introduction about you, and then wanted to hear a bit from you on the DPDP side, how you are getting the request from the customer side, why they're worried on the automation of the consent piece.
Sure. First things first, thank you, Himanshu. Thank you, GoTrust, for doing this. My name is Arya Tripathi, and I apologize for the technical glitch that I was facing at my end. Just to a step back, the Digital Personal Data Protection Act obviously relies significantly on consent basis of processing. There are only limited alternative basis of processing, but the purposes of processing are already baked into the provision itself. So they are best viewed as exceptional or those very rare situations where those purposes can be relied upon and processing can be undertaken without consent. For all the operations that are being currently undertaken, consent stands as the primary basis of processing. The relevant provisions of the DPDP Act provide for two primary requirements. One is to provide a notice before or at the time of obtaining consent, and then recording consent through a certain kind of standard. Now, just to break down further, the notice for consent, the law also provides an itemized and a minimum list of requirements that needs to be captured in the notice for consent. These are number one, an itemized list of personal data that is being processed, specified purposes and specifications of what services or use cases that are enabled to processing, a communication link and other description of available means that a data principal can use to exercise the processing. And lastly, the ability of the data principal to reach out to the Data Protection Board for compliance with the DPDP Act. So these are the primary requirements. This allows flexibility to businesses to evaluate what additionally can be disclosed in notice of consent. Therefore, the question comes whether there is a need for anything to be additionally included. I will draw here the attention of the audience to the requirement which states that further amount of detailing that empowers individual to be in a position to provide informed consent may call for inclusion of other aspects as well. Because eventually it is going to boil down to whether adequate degree of information was disclosed for an individual to signify the consent. Now, fast forward to consent. The standard is, of course, very high under DPDP. It says that it has to be free, unconditional, unambiguous, specific, explicit, and a signified affirmative action. This simply means that implied consent per se is no longer going to be the basis for processing. Drawing comparison with what the instant law is, SPDI rules require written consent, express written consent, for the purposes of processing of sensitive personal data. But because DPDP does not distinguish between personal data and sensitive personal data and requires consent for processing of personal data, for all kinds of processing, this degree of consent needs to be satisfied. Alongside, the burden to prove that consent has been validly obtained is on the fiduciary being the entity that determines the means and purposes of processing. Now, this obligation or this burden of proof rather requires obviously to maintain versions on the consent, timestamps on the consent, maintaining basically the log of the consent that has been obtained. With that, I would stop, Himanshu. That I think gives like a very high level overview of where we are headed in terms
Thank
of
you, thank you.
consent per
So,
se.
Arya, one request, if you can also kill the camera because I see the internet is a bit of an issue. So I just killed mine. If you can kill yours,
All right. Sure.
then the voice will be much better. Yeah.
Sure.
Thank you. So thanks for giving the brief introduction about the DPDP and how the consent is mandatory and how the data fiduciaries are responsible for it. Today's focus was on the automation part of it. So I just directly jumped on the automation deck. What is consent automation? You mentioned that maintaining the record of processing activities, and then the evidence related to the consent collected needs to be maintained. So we just break it down into 5 pointers. So it's exactly the things which you mentioned. Issue notes under section 5 to consistency. Record clear affirmative actions as evidence of consent, maintain retail consent records, enforce withdrawal of consent across processing activities, demonstrate compliance with section 5 and 6. So this becomes a must have need as per the law. At the same time, the records which has been maintained are or should be immutable. What does that mean is that at any point of time, if you need to prove in the court of law, you can prove that each and every record which has been collected is immutable. So there has to be mutable records. ID, every time the consent when it's collected. You cannot just go and update the database. You have to maintain a new record. So every time a new consent comes in, you have to maintain a new entry in the area. On this part, on the automation part, how do you look at it from the legal view of it? So I just gave a bit of technical side of it. What the technicality the companies have to think of if they want. How do you look at the legal side of it?
Sure. First and foremost, I feel that uh, it is imperative to have consent notification, manner of sending the consent required, digitally enabled at all your digital touch points from where you collect data. That could involve your website, it could involve your application, it could even involve if you have a WhatsApp channel, because every time you collect personal data directly and indirectly, there has to be a processing basis. So, a better way perhaps to present this would be depending actually on your volume of users. If you are primarily a B2C business or a B2B2C business, not having an automated consent model may necessarily mean that there is a lot of documentation, a lot of proof that has, which may not be the best way to look at this. Therefore, consent automation, as you rightly mentioned, somewhere becomes a sort of necessity, even though it's not precisely called out in the law that it has to be an automated process. Just from managing the volume and the scope of consent, which is first you give a notice, document consent, allow them the rights, which is to access, to modify, to erase, to withdraw consent, and even to raise grievances. I feel all of these are indicated to be in an automated fashion. Here, I would introduce the concept of consent managers. uh, the law provides for a unique market intermediary that is actually going to provide consent management solutions. The consent manager will be a registered entity with certain thresholds that they have to registered with the data protection board, and their obligation would be to remain to operate in a data blind fashion but manage the consent for data principles. So that's the role of the consent manager.
So I see that there's a bit of trouble, and I read the chat. The Arya's voice is a bit lagging, so I will just repeat what she mentioned. There was a bit of a lag in the beginning, but later it improved. Now I see that Arya is struggling a bit, so no worries. Um, um, what she was mentioning about the difference between when you collect the consent, there is something called a consent manager, which you are aware of, and then in parallel to the consent manager, we have consent governance systems. So there are two things. One of first of them is the consent manager. Consent manager has to be if you look at consent manager, it's view from the data principal point of view, and then if you look at the consent governance systems, they are from the data fiduciary point of view. If you keep this picture in your mind, then you will have very clear understanding, okay, how the consent within the DPDPA is structured basically. Now what happens is you have to collect the consent, manage the consent end to end, create the immutable record, demonstrate the history of all the consent collected. But at the same time, you have to share the consent to a third party. And this third party whom you're sharing is a consent manager in this case. And why you have to share it to a specific third party? Because that is what the data fiduciary has registered with. Now, this becomes tricky. And there's not all the clarity is there yet. Who will be these companies, third parties registered? So registration is open. I guess will be open with Data Protection Board on this part. So we all are working on it together with
Hi,
other
Ananya. Okay.
uh,
I'm on a call.
Arya, thanks. Your internet is a bit, you're struggling with the net bit, a bit. Maybe you have to switch the Wi-Fi or the go to the 5G network if possible.
Sure, sure. I think I am.
So I was
I'm
just
in my
repeating,
office, but then there's a yeah.
yeah,
No, no. Please carry on. Please carry on.
somehow. I was just repeating the golden words you mentioned, so that gives them a perspective of a consent manager and a consent governance ecosystem, so that people can understand why there are two terminologies going around and what's the difference. So all the responsibilities which you mentioned are with the data fiduciaries. They have to maintain the record, immutable record. So I repeated that so that we can have a very clear understanding of it. And you see how the consent automation supports the DPDP compliance. I think Ara, you are trying to mention a bit of this, and then your internet
Yeah.
got disconnected. If you please go ahead
Yeah.
and then we can take it. Yeah.
Sure. Sure. So to continue from where I got disconnected, we were talking about consent managers. So the idea is that organizations would be registered as consent managers, but they would be pretty much providing consent management solutions, which would be automated tools. So they would be perhaps expected to comply with an interoperability set of standards so that they can honor their obligation of porting data, which is specific to the consent managers. So in sum total, if you have a larger user base, a larger base of data principles, and your primary processing basis is looking like consent, such as in the case of e-commerce entities or social media entities, having automated consent is perhaps the best way to go about this, because manually it would be very, very difficult to first serve up the notices, obtain consent, honor the obligation to actually provide an option for accessing the notice in 22 languages. And then eventually, all the rights that are there, Himanshu, under DPDPA are connected with consent. For example, a right to access is applicable where the processing has been premised on basis of consent or voluntary submission. Therefore, if we have to take a 360-degree view of DPDP, a chunkier part of it is relating to consent and the necessary rights and obligations that flow out of it. Given the fact that if there is a lot of volume of data that you're processing, a lot of data principles that you're interacting with, consent automation is likely to be the best way to approach compliance under DPDP for consent purposes. Needless to state, of course, the content drafting part of it and all of that can be handled, but eventually the consent flow and the processing life cycle, this becomes an important piece of tech intervention that will help compliance. Over to you,
Hmm.
Himanshu.
Anna, we lost the last 5 seconds of the bit because of it. So if you can repeat that one.
I was saying, sorry, my bad. This is a bad network day for me, I guess. I was simply saying that to be in a position to comply with the consent automation for bigger companies and larger data processing basis looks like the only possible way to be doing this. Because I cannot imagine of a situation where organizations would be able to fully manage consent and accordingly design their processing life cycle.
Thank you. Thanks for that. Then let's continue further. Um on the pieces, what just summarize a bit what you just mentioned was maintain centralized purpose-wise consent records, whether you're developing it yourself or you're using consent governance tools like ours. You have to do this. Preserve traceability between notice, consent, and use. So you have to very specifically tag the the purpose, the version of the notice, the consent which has been collected, the language on which this consent was collected, all together with the touch point at which touch point you are collecting the consent. So all of this has to be together. Again, same thing. Um this mapping is important because in case the consent is gonna, let's say the notice is gonna expire, so you have to make sure that all the consent which were collected on that notice, the version of that notice, you have to reconsent them, or at least you have to re inform the principals regarding that specific change which has been done in the notice. So that's very small things but very important, that how you have to stitch this whole complex web together, because there are multiple actors which are playing in it. So we have to make sure that we are compliant with that process. Then enforce withdrawal of consent system wide as required under section. So enforce withdrawal of consent. Okay, it's very simple terminology. If I say uh, forget me, delete me, those kind of buttons which you already have implemented across your applications long time ago, but they were not enforced. Now the law says enforce them. So I can choose to withdraw my consent. Withdrawing my consent might result into multiple sub functions or sub triggers to be called. Number one, it can be your uh, withdrawal of marketing. So you will not start receiving the marketing updates. It might be very specific marketing uh, targeted depending upon as a company how deep you have implemented the consent. So if you talk about the marketing, you can have a general marketing consent. You can have a marketing consent for the new product launch. You can have a marketing consent for the discounts or the offers coming up. You can have marketing consent for the Diwali festival, Holi, Eid, and so on and so forth. So you can have multiple level of sub consents taken under a tab. Now if you say I have a general marketing consent and I do everything I want to, that doesn't work. It has to be granular to the level it fits the purpose. Now step one was taking the consent and then giving the possibility to withdraw it. Now withdrawing also can be at multifolds. Now I want the consent on uh, I want the consent on the marketing, but I do not want to have a phone call. I don't want to have WhatsApp. I just want to have an email, or vice versa. So you then go to the preferences. So withdrawal is tagged to the preferences also. Then okay, what preference I have withdrawn? So it is withdrawal of marketing consent for sending me an SMS, or it is a withdrawal of marketing action on the emails. So whichever. So that's the level it goes, and that's what you have to think of when you are building or selecting a partner. How which level it can offer you the services. Then ensure the readily available evidence to demonstrate compliance. So as I mentioned a few minutes ago, that has to be verifiable consent, where immutable records are processed. So every time a consent is given or logged, you always have to create a new entry in it, rather you update the records basically. So that's the automation is key elements of consent. So centralized consent, I mentioned. Dynamic consent logging, I just mentioned a minute ago. Automated notification reminders. This is very important that as soon as the consent is expiring, consent has a modification happening, like I gave an example of the notice changing. So you have a capability to automatically inform the end consumer or data principal in this case, or send a reminders if, let's say, there is a scenario where uh, data principal has asked for withdrawal of a consent. So you withdraw the consent, but again, as per company policy, deletion should happen in 6 months or 1 year down the line. That means you cannot use his data, you cannot send him the marketing emails, you cannot market on him, you cannot do data process analytics on him. But still you can request him for further more consent or the new consent. So you can send him a reminder, if you give us a consent, your data will be deleted. So you have to inform him on his data deletion process. And while informing him, you can request him that if he gives his consent, his data can be on the platform for further longer time, to avail more discounts, avail more offers. So these are the few things which you have to think of while designing these automations on the consent part. Because if you look at black and white, then you have to delete 50-60% of the data which you have of your customers. Makes no sense to do so directly. So you have to do every bit of it, so that you can go get max customers as possible. Okay. So I'm still looking at the chat. The voice is a bit breaking of an area, so I will just mention that voice will improve. Okay. So there's a few bits which are very important. I'm also giving examples because while implementing these uh, integrated withdrawal mechanism, like I explained, audit ready reports. So all of this becomes the key. Ara, you want to mention anything on this part? Any key element which is missed here, or you have anything which you've seen with your customers? Any specific bit which is missing here?
Just on the point, no, not something from a missing perspective. I just wanted to also complicate the problem statement a little more to bring in the concept of verifiable consent. Verifiable consent is actually a statutory obligation where a fiduciary decides to process the personal data of a minor, that is anybody below the age of 18 years, and of those who are persons with disabilities. Now, the rules clarify further how this verifiable consent can be obtained. It is a mix of due diligence obligations combined with either obtaining a self declaration or verifying the identity of the parent or the lawful guardian using tokens. So, when we are looking at the entire consent process, I feel there is also a degree of granularity that is needed where the processing involves personal data of minors and PWDs, where the identity of the parent or slash the lawful guardian has to be verified before processing activities commence. So I feel again this is fairly tilted towards involving technology tools that can enable businesses to actually, number one, where there's a self declaration, access the relevant data that is there to verify that self declaration form and identity of the parent slash lawful guardian. Second, where we are looking at, say, verifying it through tokenization tools, again, it may seamlessly connect when you have a consent automated process. And therefore, all of these combined, I feel, heads to a strong push around consent automation.
Thanks. I think also running at the time. So difference between the automation and the manual part. A lot of people we already know that the getting manual anything manual is very challenging, but a bit on the consent part. Fragmented consent captures across website, apps, CRM systems. Even if you get this automated, it is a big challenge that you have to maintain the versions notices of the consents, which is collected where. So it has to be combined. And then, as per law, we have to process it under 72 hours, so there cannot be further delay. And high compliance costing audit, as you know that, if you have manual efforts and you need to put a lot of efforts in it to combine it. Automate consent lifecycle with GoTrust. So what we already talked about it. I'm not gonna discuss it again with you, but that the importance of the consent is, you have to have model notice, centralized consent, preference center to allow the principals as a view for them so that they can come and manage their preferences, immutable audit records or audit trails like we discussed a lot, and instant withdrawal. So and the system that we have designed where all of these processes are happening fully automated, and then there's a further level down deep, which is also very interesting, is how the workflow, every trigger, every instant withdrawal triggers an update to the subsystems down below within the ecosystem of the data fiduciary. Now what does that mean is, it means that every time the consent is withdrawal, a CRM or the marketing CRM or ops CRM is updated that what is the latest information regarding that customer is. So this, you have to understand that it becomes very important uh, to make sure that the end systems are updated and they are not uh, left that some other process, or it will be updated later end of the day, or in a batch process, because the consent has to be automated and has to be near real time, if not real time in your cases, because there's a timeline also from from the legal point of view, that how quickly the consent should be processed, which is very critical. Uh, there's a question coming in. How can we take fresh consent for all data we have accordance in mandate of DPDPA? How consent manager can help us in that? Take a fresh consent for all the data we have in accordance. So you have to see all the. If I read the question correctly, that you already have. a lot of consent, a lot of data which you have already in your ecosystem. Let's say you have existing customer base of 1 CR customer, and let's say you are a bank, so people are there. So customers are already there. Now the challenge is not about taking the consent. The problem is you have taken the data of the customer to process it for a specific purpose, that is opening the bank account, but you are using it for marketing, analytics, internal product development, and so on and so forth. For those purposes you don't have. So ideally speaking, if you do not do any thing else other than opening the bank account of a customer, you don't need a consent. Because you're using it in the further systems, your analytics systems, your marketing systems, your new product launch is being happening, therefore you have to take the consent for all other purposes for which you have not taken. I hope I was clear then explaining that. Okay.
Himanshu, can I
uh,
just
yes, please add.
add to this further? So there are two different provisions that will help the audience understand this better. One is Section 5.1, the other one is Section 5.2. So Section 5.1 says how you will give a notice. Section 5.2 deals with personal data, which is legacy personal data. That is data that you would have collected prior to the commencement of DPDPA. The law is very clear on this, that if you have valid consent historically, you can continue to process historic or legacy personal data by providing number one, a notice to the data principal, number two, enabling an opt out mechanism. There is no need for taking fresh consent if you have already obtained some degree of consent, be it express or implied. You can continue to process, but you will need to give a notice, which is very similar to the notice that you will provide for fresh consent. But there is no ask for obtaining specific new consent. The alternative is what is being offered here. That is, provide an opt out link, which means that if the data principal, after receiving the notice, wants you to either limit processing or cease processing, they are in a position to exercise their opt out right. So to break down this, for future processing will need to be married to a particular processing basis. Consent is the primary basis where you will need opt-in or affirmative consents pursuant to the notice that you would be providing. However, for legacy personal data, being data that is processed historically, you can rely on giving a notice and an opt-out mechanism.
True, but 90% of the customers I talk to, they're willing to give a notice, but without opt out options. They won't opt in.
That may not.
So
I
that
mean,
that's
it
very
is completely
important. That
business
how we look at
possibility,
it.
but I feel but I personally feel that opt-in is even more trickier because there is so opt-out is a smaller benchmark, smaller standard currently prevalent. I don't see at least the businesses that I have been interacting with, including BFSI clients and healthcare clients, they're more keen on relying on that opt-out mechanism because mapping historical data, identifying who the data principal is, and serving up new notices for consent with an opt in will be significantly difficult, which is why the law even is tilted to state that while we understand consent is the primary basis, if you have historically obtained a consent, you can continue to use it provided you give an opt out. Because the moment you move to an opt in for even historic data, should the data principal not give their consent, the only outcome that you have is to go ahead and purge that data set. I'm not sure if businesses are okay with that, but at least at my end, advising clients on DPDP implementation, I see a significant degree of resistance in obtaining consent for historic personal data.
No, I see the same. Just telling you the preferences are based on the knowledge which prevails in the industry, but that's why you come in and help the customers, to pick the right choice. We as a provider of the services, we make sure all the possibilities are available to automate the consent, whether they want to go opt in, opt out, multi jurisdiction, they want to work in India, outside India, Middle East. So different geographies brings in different regulatories, compliances accordingly, and then we facilitate on these parts. But thanks, Arya, uh, to add the value. I'm really sorry, guys, because of the bit of the internet lagging. There was some bits and pieces where the voice was not clear, but I hope at overall the conclusion which we wanted to send the message is clear to you. If you have any doubt, any clarity, please send me the questions directly on the chat, and or on contact me directly. I will pass on the question to Arya, and then we can give you the detailed answer to those questions if you have any doubt. Thank you for now, and nice talking to you guys, hearing from you. Anything you want to add, Arya,
Thank you,
before we
everyone.
close the call? Yeah, thank you.
Nothing. I just feel that this is, as such, the law is a new law. We don't have a predecessor. My only one last concluding statement is that there is flexibility. The absence of bright line standards also translates into flexibility, which is an opportunity for businesses to really structure it in a manner is compliant and also seamless for their business operations. Happy to take up any questions, and thank you, everyone.
Thank you, Arya. Thank you. So I will close the call now, and then as and when question comes, we can contact one on one. Thank you.